When your city council, planning commission, or other local officials meet to make policy decisions that affect your community, Utah law ensures that you have a right to know what's happening. This is the Open and Public Meetings Act, or OPMA, and it rests on three essential pillars: notice, openness, and records. Each pillar protects transparency in government. First, understand when OPMA applies. The law governs any public body that is any administrative, advisory, executive, or legislative body created by law, consisting of two or more persons, spending public funds, and making public decisions on public business. City councils, planning commissions, boards of adjustment, they're all public bodies. OPMA applies when a quorum of that public body convenes for the express purpose of discussing, deliberating, or taking action on matters within their jurisdiction. A quorum is typically a simple majority of the membership. A chance or social gathering is not a public meeting under OPMA, unless it's being used to circumvent the law. Now let's look at the first pillar, notice. Every meeting requires at least 24 hours advance public notice. This is mandatory, not optional. The notice must include three critical elements: an agenda listing topics with reasonable specificity, date and time, and a meeting location. Where does the notice published? Two places: the Utah Public Notice website, accessible statewide, and at the public body's principal office like City Hall or the county building. And here's your protection. A public body may not take final action on any topic that wasn't properly listed on the agenda with that advance notice. The only exception is an emergency meeting, which has its own strict procedures. The second pillar is openness, and here's the foundational rule. Meetings are presumed to be open unless closed in accordance with specific statutory procedures. The default is always on openness, not closure. So when can a meeting be closed? Only for specific statutory purposes, and only by following the correct procedure. First, the public body must be in an open meeting with a quorum present. Then, 2/3 of the members present must vote to close the meeting. Before going into closed session, the body must publicly announce the specific statutory reason for the closure. And what topics permit a closed meeting? The law provides a very limited list. Common examples include personnel matters, such as discussing an individual's character, professional competence, or health; strategy sessions about pending or reasonably imminent litigation; discussing real property transaction where the public discussion would prevent the best possible terms; or deployment of security personnel or systems. But here's a critical limitation. No matter what's discussed in a closed meeting, final action cannot be taken there. All votes to approve ordinances, resolutions, contracts, or appointments must happen in the open meeting where the public can observe. This is mandatory. The third pillar is records. For all open meetings, written minutes must be kept detailing all matters proposed, discussed, or decided, including each member's individual vote. Draft minutes shall be made available to the public within 30 days. Additionally, an audio or video recording of the entire open meeting must be made and posted on the Utah Public Notice website within 3 business days. For closed meetings, a complete unedited recording is required, though it's protected from public disclosure under Utah's Government Records Management Act. If the closed meeting is exclusively for personnel or security discussions, a sworn written statement by the presiding officer may substitute for the recording. What happens if a public body violates OPMA? Any final action taken in violation of the open meeting requirement is voidable by a court. That means a judge can invalidate decisions made without proper notice, without openness, without proper record. Compliance isn't optional. It's how government protects both the public's right and the validity of its own decisions. So here's what OPMA guarantees. Notice at least 24 hours before meetings, openness as the default with closed sessions only for specific statutory purposes and following very strict procedures, and records, written minutes and recordings that create a permanent, accessible account of government action. These three pillars work together to ensure that the people's business is conducted openly. If you have questions about OPMA, you can contact the Office of the Property Rights Ombudsman.